All right, my people, we have a breaking news, and this El-Rufai situation is no longer just political drama. It has now fully entered the zone of national security and criminal prosecution. The DSS is now set to arraign Nasir El-Rufai in court on February 25th over alleged cybercrime and breach of national security. Not questioning, not invitation. Arraignment in court. That means formal charges, formal legal battle, formal prosecution process. And look at how fast everything is escalating. First, airport confrontation, then EFCC invitation, then ICPC custody, now DSS charges, and now a court arraignment over cybercrime and national security. Before we go into the full details, please make sure you like this video and subscribe so you don't miss any of our premium updates here on the channel. Also, please stay with me till the end of this video because we'll be exposing a lot of hidden secrets that most mainstream media won't put in public. Now back to the news. You see, this is not a small legal situation anymore. This is a multi-agency case involving EFCC, ICPC, and DSS. Once multiple top security and anti-corruption agencies are involved in one case against a former governor, it automatically becomes one of the biggest political and legal stories in the country. Now let's break down the main allegation because this is where the matter becomes extremely sensitive. The DSS is accusing El-Rufai of unlawfully intercepting the phone communication of the National Security Advisor, Nuhu Ribadu. That is not an ordinary allegation. That is a national security allegation. Because the NSA is not just a political figure, he is at the center of Nigeria's security intelligence structure. His communications involve security operations, intelligence decisions, and national strategy. So if anyone is accused of tapping or intercepting the NSA's phone, the government will naturally treat it as a very serious offense. According to the charges, DSS is saying that during a television interview on February 13th, El-Rufai allegedly admitted that he and some associates intercepted the NSA's phone communication. That statement is now being used as part of the evidence against him. That is a very critical legal point, because if a person is accused based on his own public statement, the case becomes more complex legally. The court will now examine whether that statement was literal, exaggerated, political talk, or an actual admission of a criminal act. And in politics, people sometimes speak strongly during interviews without expecting those words to later become legal evidence in court. But once national security laws and cybercrime laws are involved, statements are no longer just political talk. They become legal material. Now look at the 3 counts filed. First, unlawful interception of communications under the Cybercrimes Act. Second, associating with individuals involved in interception and not reporting them. Third, using technical systems that allegedly compromised public safety and national security. These are heavy legal accusations. This is no longer about corruption investigation or political disagreement. This is about cybercrime law and national communications law. That moves the case into a more serious legal category than ordinary political investigation. Another major development is that DSS reportedly took him briefly into custody after he spent 2 nights with AFCC. That means he has already moved between different agencies within a very short period. Think about the pressure surrounding that situation. From AFCC custody to DSS involvement, now to court arraignment. For any political figure, that sequence is intense. But the political context around this case makes it even more explosive. El-Rufai had earlier accused the National Security Advisor, Nuhu Ribadu, of orchestrating moves to arrest him. Now, the same issue involving the NSA's alleged phone interception has become the basis of DSS charges. That creates a direct conflict narrative. One side says he unlawfully intercepted communications. He says he listened to conversations that suggested plans to arrest him. This turns the case into a high-stakes legal and political confrontation. Supporters of the prosecution will argue that national security communication interception cannot be tolerated under any circumstance. They will say if anyone, no matter how powerful, illegally tapped sensitive security lines, it must be investigated and prosecuted to protect national safety. But supporters of El-Rufai will likely say something different. They will argue that his statements were political disclosures, not criminal confessions. They will question whether the charges are connected to his recent public criticisms and accusations against top security leadership. This is where public perception becomes divided, because Nigerians are not just watching a legal case. They are watching a political figure who has been very vocal recently, now facing multiple legal actions from different state agencies within a short time frame. That sequence naturally raises political suspicion in the public space, whether justified or not. Another angle that cannot be ignored is the legal foundation of the charges. The DSS is relying on the Cybercrimes Amendment Act 2024 and the Nigerian Communications Act 2003. These laws specifically address unlawful interception of communications and misuse of technical equipment affecting national security. That means the prosecution is framing the issue as a digital security offense, not just political misconduct. And in today's world, cybercrime laws are taken very seriously because digital surveillance and communication interception can affect intelligence operations, military planning, and national stability. Now imagine the courtroom implications. If the prosecution presents strong technical evidence, witness testimony, or digital traces, the case could become a landmark cybercrime trial involving a former governor. But if the case relies mainly on public interview statements without strong technical proof, the defense team will challenge the interpretation heavily. This will likely become a highly contested legal battle. Another serious factor is his previous custody under ICPC, over alleged corruption linked to his time as governor. That means he is facing more than one legal pressure simultaneously. Corruption investigation on one side, cybercrime and national security charges on another side. That combination increases the overall gravity of this situation. For ordinary Nigerians watching this unfold, the main concern is institutional credibility. People are asking whether this is purely a legal process driven by evidence, or whether political tension is influencing the speed and intensity of actions taken against him. Because when legal cases involve high-profile political figures, public trust in the fairness of the process becomes extremely important. At the same time, it is also true that national security allegations cannot be treated lightly by any government. If authorities believe that sensitive communications were intercepted, they will act strongly regardless of the political status of the accused. That is the dilemma Nigeria is facing right now, balancing rule of law with political neutrality. Another key moment will be the arraignment date itself, February 25th, before Justice Joyce Abdul Malik at the Federal High Court in Abuja. That court appearance will move the matter from media narratives into formal judicial scrutiny. Charges will be read. Legal arguments will begin. Bail considerations may arise. And the legal process will officially take control of the story. From that point, the case becomes less about interviews and more about evidence. Politically, this development also signals rising tension within elite political circles. El-Rufai is not a minor political actor. He is a former governor, influential figure, and outspoken voice. Any prosecution involving him automatically carries national political weight. And the closer this case gets to full trial proceedings, the more it may shape political alignments, opposition narratives, and public debate ahead of future political cycles. Right now, one thing is clear. This is no longer just an investigation phase. This is prosecution phase. And once a case reaches arraignment stage, it means the state believes it has sufficient grounds to formally charge and pursue legal action in court. But the final outcome will not be decided by political arguments, media reactions, or public sympathy. It will be decided inside the courtroom, through evidence, through legal interpretation, through judicial ruling. And until that process unfolds fully, the tension around this case will continue to grow because it sits at the intersection of law, national security, and high-level political rivalry. This situation is still unfolding, but it has now entered a very serious legal chapter that could have lasting implications for politics, institutional trust, and the relationship between the political power and security agencies in Nigeria.
So before we talk about guilt or innocence, let us ask a question. When does interview stop being a conversation and start becoming a criminal charge? Because right now, the situation is sitting quietly inside El-Rufai's case. But amid the emotional public discourse, Iniberefion's intervention has introduced a legal perspective, and that is the reason for this video. But first, let us get the context of this conversation. It's no longer news that El-Rufai has been on the trends for the past days. So, Malam El-Rufai is reportedly in custody and he has been charged with cybercrime. But according to the charge before the Federal High Court, the allegation stems from the statement he made during an Arraign interview on the 13th of February 2026. Now, let us break down so that everybody understands and follows clearly, because this is where law and interpretation collide. What does the charge actually say? In simple terms, count 1. The prosecutor suggests that El-Rufai admitted during the interview that he and others unlawfully intercepted, meaning wiretapped, the phone communications of the National Security Advisor, Nuhu Ribadu. So this is a very serious accusation because unlawful interception of communications is classified as cybercrime. The count 2 goes further. It claims that El-Rufai stated he knew someone who unlawfully intercepted Ribadu's communication, but then failed to report the person to the authorities, meaning that even if he did not do it himself, the charge says knowing and not reporting is an offense. But human rights lawyer Iniberefyon reviewed the charge, and that is the basic for this conversation. So let's explain them without legal jargon. So Inibere points out something technical but interesting. He said that under Nigeria's National Security Agency, the agency legally created is called State Security Service, that is SSS, not Department of State Services, which is DSS. In other words, Inibere is saying SSS is the official statutory name, while DSS is commonly used operationally. So his argument is about legal precision, because in criminal law, technical accuracy matters. So, if the charge mentions an entity not written exactly as created by law, a defense lawyer might question the drafting. But here is a practical reality, because courts often treat DSS and SSS as referring to the same institution, since everyone understands they mean the same agency. So this may not destroy a case, but from a strict legal standpoint, it remains an interesting observation about drafting accuracy. It's like someone legally named Michael Okafor, but widely called Mike Okafor. So if the document says Mike instead of Michael, does that automatically collapse the case? Another concern raised by Inibere is that DSS is primarily an investigating agency, meaning that they investigate, they gather intelligence, but prosecution usually flows through the Attorney General, Ministry of Justice. So the legal question becomes, was this charge properly filed? Under whose prosecutional authority? Because procedural issues sometimes matter greatly in court. And the most interesting part is the third part, which is, was this a confession? This is where things get interesting, because the charge appears to treat El-Rufai's TV's comments as if it were a confessional statement. But under the criminal law, a confession typically requires clear admission. It has to be voluntary and it has to be properly cautioned. That is to say, you have situations like you are obliged to say nothing. You have to be informed that this is a confession. So, can a TV interview without caution automatically become a confession? Because political speech is not automatically criminal confession. So, did El-Rufai actually admit guilt? This may be the strongest legal debate, because El-Rufai, according to the report, did not say, I wiretapped the NCA. Instead, he allegedly implied someone else intercepted communications and informed him. So the distinction is crucial, because legally, alleging something happened and admitting you committed it are two different things. Also, repeating information does not exactly mean you're confessing to participation. And so, Nigeria's constitution protects individuals from being forced to give evidence against themselves, meaning that no one can compel you to confess. And also, silence cannot equal guilt, even when the authorities suspect wrongdoing. So this conversation is bigger than personalities, because this case touches on how political speech is interpreted, whether media interview can become criminal evidence, the line between the allegation and the confession, and most importantly, the procedural precision in prosecution. So if public interviews are now being treated as automatic confessions, then every political conversation becomes a legal minefield.